Payment of costs concerning a claim, and I fortunately have never had this situation. First of all, I have had probably 10 times more protests that I've dealt with in my time in procurement than I have claims, so I have much more experience with protests than claims, but I've never been in this situation, and I guess this is a protection for an agency just to say no, 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 no matter how meritorious a vendor's claim might be. So the rule is that if the Board of Contract Appeals determines that the conduct of agency personnel regarding a contractor claim is in bad faith or without substantial justification, the Board of Contract Appeals may require the agency to pay the reasonable costs of the contractor filing and pursuing a claim, including reasonable attorney's fees. And I don't know if this has ever been applied against any state agency. Maybe it has, but it's out there. And there have been a number of laws that have been submitted in the legislature to try to get more than just this, to actually have damages paid or things of that nature. And this is the only thing that's ever gotten through, and they've tried to get something parallel to this on protests, and they haven't, it never has passed. So you can't just, in bad faith, say no and just deny, deny, deny.
But this is when the contractor has to win the claim.
Well, yeah, the vendor obviously is going to win the claim, and beyond winning, it isn't just simply winning.
Right.
The Board of Contract Appeals must make this decision that this is really, really bad. You agency personnel did something bad. You deliberately denied this, you knew it was valid, and you went through, jumped through hoops to try to keep from paying the money, and it just is, it's almost the equivalent of you're doing a fraudulent action or something. So hopefully there is no agency that would ever do something that this would be invoked against them. And I say I'm not aware that it ever has been applied, but it is there on the books. It's in the law. Now we'll come to a little story, Aesop's Fables. Talking about, we've said that there could be formal negotiated settlement, informal negotiated settlement, an actual decision, etc. So I'm going to do an example of an informal negotiated claim example. DBM has a contract for collection of urine specimens for both employees who are under certain circumstances must undergo urine tests, and prospective employees for certain categories of employment, state police, prison guards, and probably a whole lot of other ones. Before someone can even be considered for hiring, they have to go and take a urine test so that we send it out and get it tested to see if there's evidence of taking drugs, etc. Or in situations where I think prison guards and various classifications of employees have to have random testing, and if there are situations of incidents, if there's, for instance, an accident involving the light rail or involving a bus, the bus driver within something like 12 hours or the light rail operator within a certain number of hours must have a urine test to be tested for illegal substances, etc. So DBM has the contract that any state agency can use for drawing the specimen that is then sent out for testing. So we have this contract, and we've had this contract since at least 1999, probably longer than that. The vendor that we had was bought by another vendor. So this is one of the changing circumstances. We had one vendor, and then the vendor is bought, and so we say, has to be a novation, which we'll talk about later, and it may or not be slide 694 where it's discussed. And the novation, we were satisfied that it was okay to change the contract to now be with the vendor that bought the current vendor. So we did everything properly, got everything signed, the contract was changed to the new vendor's name, and whether it was a couple weeks, whether it was a month, it was shortly after we did the novation when now the new contractor came back to us and in writing said they wanted a price increase. And we said, no. What it said, and this is going to sound a little strange, that, well, yes, we read the contract before we bought the company, but until we actually owned the company and had to actually perform under the contract, we didn't really realize what some of the words in the contract meant. And so now that we've been performing the contract for a couple weeks or a couple months, whatever the time frame was, and we see what the actual situation is, we think we're entitled to a price increase. And he alleged that a price increase was needed because he said there were too many places where they would have to send people to make the collection. Because what we had specified was a list of 20 or 30 specific sites all over the state, because collections could be taken in Salisbury or Oakland or Cumberland or wherever. So we had named something like 20 or 30 sites where collections typically were required. Plus we had a provision that says, and upon notice, we can add any other location. And you, the vendor, have to go to that location at the time specified and have someone there qualified to take a specimen and do all the things necessary for that to be done in a secure manner so it can be shipped off for drug testing. So the first thing he claimed was, well, there's too many places where we have to send specimen collectors. And again, that's nothing that wasn't in the contract. And he said, and not only are there too many of them, but they're all over the place. You got places in Oakland and Cumberland and places in Salisbury. And it's like, yeah, because it's the state. We actually do go from the western part to the eastern part, and from the Pennsylvania border down to Virginia and DC. You know, it's the state of Maryland. We have offices everywhere. And we're not going to have the people that need testing all go to one place or just a few places, etc. We try to make it relatively convenient for the people getting the testing. And we'll wait till we get the door shut. So they said they were too far apart. The lead time to make collections was too short. We only, I think, had to provide 5 days' notice in most circumstances, and we could request it in as little as a couple hours for one of these incidents. If there's an accident involving the light rail, as I said, there's federal requirements that the testing must occur within 2 hours, 5 hours, something like that. And so there has to be somebody that can be called in on virtually a moment's notice, and within a very short time frame, they have to come to a specific location where the driver or the bus or the light rail or whatever it is going to be, and they have to draw a specimen under controlled circumstances. So he claimed that there wasn't enough lead time. And what he was looking for was, if I send someone out to a given location, I don't want them to go out there and just draw one specimen, because our price was a price per specimen. And if they go to a place and have to drive 20 miles and get one specimen, they will simply get the cost of, I think it's only like $12 or $15 per specimen collection. Excuse me. Yes, I will ignore my boss for the time being. All right, let's see. What he wanted was, instead of coming every 5 days or something like that for 1 or 2 or 3, he wanted it to be 10 or 15 days so that he was assured of maybe 10 or so collections. So for the expense of sending someone out somewhere, they were going to get at least 10 or some minimum number of payments to make it worth their while. So, and he said that it was hard to schedule staff to go all these different places in all this time frame. And the first answer we said, well, all of this is in the contract. That's what we said. We want the flexibility to do this when we need something to be done. So when you bought the contract, you certainly should have known what was in the contract, that we had the right to do this. And I guess his answer was, well, yes, I read it, but I didn't know you actually did it. Okay. So we denied the request for a price increase because there was no increase in the services being delivered. He was not going to give us anything different than what we had specified. He just wanted more money to do the same thing that was already required. And as I've said now for the 201st time, can't do it. It's a Maryland Constitution prohibition against doing that. So we said no, and the vendor didn't just say, okay, and go happily or unhappily into the sunset. The vendor threatened, got nasty at point. Number one, well, I'm just going to stop performing the contract. You don't give me more money, I'm just going to stop doing it. Like, nah to you. Also, I'm going to write to the governor, I'm going to write to the legislature, and I'm going to complain about you nasty state agency and what you're doing to small vendors like me and how you're making it unprofitable for us to do business. And he actually did file a claim. Now, he didn't do this that we know of, but he did do that. He filed a claim with us. We could have denied the claim, as I've said, in the contract. It's been in the contract for as many years as we've had the contract. And each vendor has, I guess to varying degrees, simply accepted it, done the work, and that was the end of it. But this vendor claimed that now he was losing money trying to perform the services under these requirements. So no question we could have denied it, and if the indication from this guy was he was going to take it all the way. And so we had the time and effort to not only write up the formal denial, but then have to go to the Board of Contract Appeals and do the response there and take the time to go to a hearing. And even though we knew we were going to win, sometimes you just don't want to go through the effort. So, even though we knew we would win, to try to avoid the hassle of fighting the claim, we did this. We verbally, I guess by phone, and I think followed up by email, said, all right, how about if we make this offer to you, even though we don't have to. We won't willy-nilly, if that is the correct word, just add sites. We will try to be very judicious about, number one, adding new sites, or number two, where we're scheduling people in terms of the sites that we already have specifically identified. We will we'll make a conscious effort to try to have at least 5 people at a given site before we say, okay, show up. That we won't do it by 1 and 2, things like that, that we're not going to, in a situation where we need or can't get 5 people, etc., unnecessarily hold up. But if we can just wait a couple days and get 5 people, we'll try to do that. Try to give at least 5 days and usually 10 days notice about the collection so they can try to more efficiently schedule their people so that they can use their other customers and try to have them scheduled at the same time they're coming for us. So he allegedly could efficiently use his collectors. So we made those 3 offers of what we would simply make an effort to do. Did not guarantee any of this, just we would try. Now obviously, doing this seemingly would not cost us a cent, so we weren't doing something that was a cost issue. And from our standpoint, we also weren't giving up anything of any great significance in terms of receiving less service. So we made this offer, and the vendor said, okay. It said, on that basis, even though he had been very nasty and used some nasty language and various things, and I can't say we had a rapport with the vendor, but on this, with at least in an email, writing in that fashion, making this offer, he said he would withdraw his claim, and as long as we essentially did what we said, he would continue to provide services.
This was all verbal.
Well, I think we put it in writing, but we didn't put it in a formal writing in terms of a response to the claim. Because what the vendor agreed to was that on the basis of this written correspondence that was not identified as being a settlement or anything of that nature, it's just, here's what we'll try to do, because we're not making any pledges. He said he would withdraw his claim and just see. And he didn't have a valid claim to begin with, so it isn't as if he was going to be timely if he let it stand and untimely if he didn't, because he's untimely and had no basis to begin with. So he said he would withdraw the claim and see what happened. So even though the vendor had no legitimate basis of the claim, we felt this informal cooperative pledge was in the best interest of the state to save time and effort, especially since, here's the other circumstances, we were going to re-procure it within 6 months, and the vendor already told us he was not going to try to win the contract again, and we did say, yay, good, glad to hear it. And I'll be frank, looking at what the vendor said, I basically agreed with him, that even though it was in the contract, it isn't reasonable to say that we can have you go anywhere almost any time for as few as one person. It doesn't make sense from a vendor standpoint. And based upon the issue of risk that I keep talking about and vendors charging for risk, I felt that perhaps we actually should put, and the next slide does say this, well, let me just read this. For the next few months, these concessions avoided serious problems with the contractor and proved to have negligible effect in terms of any sacrifice in needed services. So the reality proved out that we really hadn't given up anything. And then what we did was, because this seemed prudent, and now this vendor had brought to the forefront some of these issues, in the new specifications, that based upon the premise that supposedly we thought we would get lower prices by putting these in the contract, these same things that we had informally offered the vendor were now in the specifications, that we would minimize the sites to as much as possible, to give 5 to 10 days notice, things of this nature.
Joel, I mean, what if there was a bus driving accident in Allegheny County?
That was different. The issue of the emergency response was still there. And we got prices for these different time frames. That if it was an urgent response, they had to do it. They bid a price for that, and that's not something we relaxed at all, because that's you have to do. The thing of how long does it take for a prospective employee who's going to be hired before they go do a drug test, 3 days versus 4 days versus 5 days, is different than there's a bus accident, you have to take a test within 6 hours. That didn't change. And that wasn't his issue, because he knew that happened maybe once a year, versus the other thing happened 3 and 4 or 5 times a week. Let's see, so we had it in the specifications, and again, because this was a nice vendor, a really nice guy, since he said he wasn't going to bid again, he was going to absolutely go to all of his competitors, since he no longer had an issue of trying to compete with them for this new contract. And he was going to let them know that the state was nothing but problems. And he was going to tell them all these terrible circumstances and the expense that he had to incur and everything. And so they're going to all know about what we've been having, and your prices are going to go up because you nasty, terrible state. And you wait and see. Even though we're not going to bid the next time, whoever does, you're going to see higher prices, because I'm going to tell them what's going on. Because, again, there's no problem in him disclosing his problems to his competitors, because he wasn't competing. So, because this vendor was very honest, true to their word, number one, he had withdrawn the appeal, and number two, the claim, and number two, he did not bid again, which again we went, yay. And so he did not compete, and we believed that in that particular instance, even though he was claiming that the price that he had to charge under the current contract that he had bought was so low that no one can make any money, and that was where he was going to tell people so the prices would go up. We got basically the same price in the recompetition that we had under the contract that he claimed was so unprofitable. And there's at least the conjecture that those concessions that we then put in the specifications might have helped assure that we got the same price. And maybe without those concessions, and we don't know whether the vendor did go and talk to all his competitors or whether that was hot air, but at the very least, we said if it's not harming us, if there's no real negative impact to us, put them in the specs. It takes some risk away from vendors. Maybe we'll get a better deal. And we think getting the same price for a new procurement that we had for one that was already in place for 4.5 years meant we got a really good deal, because usually prices go up. And if you're getting the same thing 5 years later, same price, you got a good deal in most instances. So that's an example of an informal negotiated claim. Obviously, it's not something that's going to happen all the time, but it is, as I've said before, a possibility. Now, here's a formal negotiated claim that I've already been told that perhaps there might be an error in what is said here. I thought this was what was described to me, and where is Gary when you need him? But anyway, when he does show up, I will have him go over this and tell me what aspects of this might be incorrect. Supposedly the situation is correct, but maybe not the resolution. But anyway, you've heard Gary talk about the vital record system for DHMH. And in the specifications was a requirement that all software be provided with a 2-year license for use by DHMH. So to the extent the vendor was providing software to do different things, they had to provide a 2-year license that the state could use that software for 2 years without additional expense. It was part of the vendor's price to install this system to begin with. It was not noticed when the award was made that the winning vendor for this contract, in an obscure manner, and I don't know how obscure it was, but all I know is supposedly in some obscure manner, the vendor took an exception to this requirement. So despite the process that was gone through to make sure that there was the meeting of the minds, after the contract is awarded, after the system was installed, when I believe when the DHMH said, okay, now we're into this second year, first year, whatever it is, and we shouldn't pay any more money for licenses, the vendor came back and said, well, yes, you do, because back on page so-and-so, we took this exception, so we never said our price included doing that. So you have a problem now. And the issue is, now what prevails? The vendor's exception, the requirement in the contract to begin with, the RFP, and normally it's the RFP, but when the vendor has an exception and you incorporate their proposal into the final document, are you incorporating their exception? So you have an actual legal question of what was the final contract? Was it what the RFP asked for or what the vendor said they were going to do, or in this case, not do? So after the system was installed, had discussion concerning the first renewal option. That's when this came up. And during this discussion, the vendor noted that DHMH would have to spend over $200,000 annually for licenses for software provided by other vendors that were embedded in the new vital record system. So you're not paying for what I, as a vendor, have created, but since I'm using as part of my system these other software programs developed by Microsoft or
Citrix,
Microsoft, NetApp, Cisco, on and on, you have to pay them because I just paid for the initial license, you have to do it hereafter, and it's $200,000 a year. And this was when DHMH first learned of the exception. This is when they found out that, oh, I missed that. So now you have the issue of what do you do?
Oh, Joe, I'd like to correct one point. It's not $200,000 annually.
It's not $200,000?
No.
It's
less.
good when you have the actual person involved. So how much was it?
It wasn't 200,000 annually. I think that what they calculated was throughout the term of the contract up to 2013.
3-4 years? So it was 200,000 over the door.
Yeah, over the course of the
contract. All right. So it's $200,000, but not annually.
Not annually.
Okay. So there will be some corrections to this. The first, and this is what Gary told me, so hopefully this is correct. First, it said no. We didn't know there was an exception. We didn't agree to that exception. The requirement of the RFP was you had to provide the licenses, do it. And the vendor said no. Did not include whatever it was. 200 instead of 200,000 per year times 2, apparently it was $200,000 period, and would not absorb the expense. My price did not include giving you a license for this additional period, for this additional expense, so I'm not going to eat this money. So I took an exception. We have the specifications. I'm not going to do what the spec said because I took an exception. I don't care about your exception. Do what the spec said. Back and forth. So DHMH countered with the order of preference of exhibits to the contract. The RFP and the vendor's proposal were both contract exhibits, but the RFP took precedence over the proposal in case of a conflict between the two documents. And if you are familiar with contracts, they always list the order of precedence. What documents control over what other documents? And we always say first is the contract, second is the RFP, third is the vendor's price proposal, fourth is the vendor's technical proposal. So, order of precedence. But then you get to the issue of what I've already said before. Well, when DHMH accepted my proposal, they essentially were modifying the RFP to delete the 2-year requirement, or if you don't take that, the vendor, will give you 2 alternatives. Either you modified your RFP by accepting my proposal, or I gave you an alternate proposal and you accepted that alternate proposal. Either way, since you have incorporated my proposal into the document, you have basically changed the RFP so that the RFP now includes my exception. So there is no conflict between the 2 documents. And each side felt it had a valid argument and refused to yield to the other side. I'm right. No, you're wrong. I'm right. No, you're wrong. I'm right. And you're wrong. And then back and forth. DHMH then filed a claim against the vendor. Is this right? Do you know?
Well, I know we wrote letters back and forth, but I don't know if the formal claim was...
Come on, Gary, get in here. This is what I understood to be the situation, that DHMH then actually filed a claim against the vendor to make it pay for the software licenses, because they'd already paid for the system. And they were going to pay for the maintenance, but the maintenance payment wasn't enough to pay for the cost of these additional licenses. So on the basis of what I understand was a claim against the vendor offered a settlement. The vendor said if DHMH would pay for the licenses of the other software, for the other software vendors, the vendor would provide DHMH with additional support, etc., valued at $200,000. Now, does that sound right?
They gave us a pot of hours.
Pot of hours.
That calculated out to this difference.
So something additional value which supposedly equaled out.
Yes.
Okay, at least supposedly equaled out. So instead of the vendor paying $200,000 in money for licenses for the software embedded in the system, the vendor would give DHMH services, etc., for which DHMH would have had to pay $200,000, but which cost the vendor less than half that amount, because the vendor always has markup. So they're giving $100,000, $80,000, $90,000 of value, which if we were paying for it at full price would cost us $200,000. So supposedly on that basis of getting something of a commensurate value, DHMH agreed to accept the offer on that premise that if it went the full way and had to get to the issue of did we incorporate their exception and thus maybe we might lose the claim, what a settlement always is, both sides give something, so DHMH agreed to take this offer and let that settle the claim and the whole issue. And now the other thing that now I find out is perhaps in question of whether there was a formal signed settlement. My understanding was there was, and now perhaps there wasn't.
There's a draft.
A draft.
That has not been
So maybe this might be another example of an informal settlement. I don't know. So when Gary gets in here, we'll try and get the answer to this and let you know what the true story was. And whatever the true story is be corrected the next time we give this.
Question.
Yes?
Do you basically agree, though, that we were in error by not addressing the exception?
Well,
'Cause it
that's
seems
something.
to me that we were in error and that the vendor was correct.
Well, that's something that has come up. I know it's come up a couple times, and I don't think it's ever gotten to an actual court scenario to find out an actual precedent. I mean, maybe it has, but I'm not aware of any. So I don't know what the final answer would be. But it has at least an element of plausibility that the vendor has a case. It's not like most claims or most protests that when we read it we say, I mean, this is almost a comedy of what they're saying because nothing has any validity. But in this one, maybe it does. And so the question is, we know if it goes to the Board of Contract Appeals, one of two things can happen. We can either be upheld, that the vendor has to provide the licenses, or the vendor could win and we're out the $200,000 that we had to pay for the licenses. And if it's maybe a 50-50 proposition, and I don't know if it's 50-50, but there's a possibility that we could be better off by $200,000 or a possibility we could be worse off by $200,000. By agreeing to this, we eliminate the possibility of being worse off by $200,000. Allegedly, we have value, a commensurate value, even though it doesn't cost the vendor $200,000 to provide this value. And hopefully it's something that we need or would like to have, so we feel that we're getting that $200,000 even though it isn't costing the vendor. If they had to pay it to Microsoft or some other software producer, it would cost them $200,000 real money out of pocket. Here it's just what they pay their employees without markup, without overhead, stuff of that nature. And so we supposedly get the value. They don't have to pay the value. Both sides can say they have something that's worthwhile to come to a settlement. And that's based upon at least an actual filing of a claim by the state or a threat or whatever the situation was. But it illustrates how you came to a settlement, and we have to find out whether it was formal and put in writing and went to the Board of Public Works, or just what the scenario was. So even if this isn't exactly what happened, it illustrates what would be involved if you got to a formal settlement where that could be the situation. So we'll give you more details. Now this one I can say with more certainty because this is the first claim I was ever involved with, from 1989. And I still remember this. It was I think it was the second time I ever went to the Board of Contract Appeals. First time for a claim. There was an invitation for bid by the Health Services Cost Review Commission to audit the coding of 2,000 medical records at certain Maryland hospitals. They had named something like 6 hospitals in the Baltimore region that they wanted medical record coding auditing. And when you hear auditing, you think of financial audits, but this was not a financial audit. That was the whole crux of this whole situation. The purpose of the audit was to see if hospital medical records were being coded properly. Hospital payments were based on diagnoses and procedures that were performed, all of which was reduced to codes. So everything, the whole thing of the medical industry, there's this thick book on, I think, ICD-9, International Classification of Diseases 9, so that there's I guess, potentially thousands of procedures and thousands of diagnoses, and every one has been reduced to a code. So, and the hospitals will build a code 51876, and they'll bill a code 27945. And every one of those codes matches a certain procedure that was done, something that the hospital did, and they have a charge for it. And the Health Services Cost Review Commission regulates charges and what hospitals are allowed to charge for certain procedures. And so the basis of this audit was to go back and see if a hospital charged a code 5000, which maybe a code 5000 was procedure A, which had an allowable cost of $1,000. The audit was for someone to actually go into the hospital, pull the detailed medical record, all the detail of what the test found, what the doctor found, what the doctor wrote, to see whether on the basis of the source documents, an experienced medical record coder would come up with that same classification 5000, code 5000 for what was done. Or would that coder, who was supposedly a very experienced, very senior person, come up with a code 4000, for instance, that only had an allowable charge of $500. And simply by being billed by codes and paying by codes, all a hospital had to do, deliberately or negligently, was come up with all kind of codes that really weren't appropriate for the procedure that was done, and they could basically make a whole lot of money by improper coding. So you do auditing to try to make sure people are honest, whether it's because they're deliberately trying to do something or they just don't have the proper people to know what coding to put down. So, reduce the codes, thick manual that translates the code in the actual words, etc. And the solicitation was to get a vendor to go in and audit 2,000 records between Hopkins and University of Maryland and maybe Sinai, but probably 5 or 6 or 7 hospitals in the Baltimore area. 5 bids were received to perform these audits. Mason bid $20,000, and I remember that vividly, $20,000. I don't remember the exact prices for the other vendors, but they went up almost in, bless you, almost in $10,000 increments. Not exactly, but roughly. You had 20,000, 35, 45, 55, and the high bid was around 65,000. So just looking at this, you're saying that's a big spread. 20, and the next one is close to twice as much. And then even these go up by a fair amount from vendor to vendor. And not coincidentally, the ones who were charging the most money were the ones who had the most experience doing this type of work. Turns out that D.R. Mason had never done this type of work before. So, Health Services Cost Review did not want to award to Mason. They didn't, in so many words, they didn't trust them. It appears both from the price and from the lack of experience that they just don't know what they're doing. They didn't know what price they should bid. We can't afford to award to them because we don't trust that they can do the job for $20,000. So, and their only experience in auditing was financial auditing. Again, they had never done auditing of medical case records. They had just been audits of dollars and cents and things of that nature. So, let's see. Auditing of medical records, coding is very different from financial auditing. It has to be done by persons specifically certified to do medical coding. It is a specific certification that relatively few people have. And it is relatively expensive to get medical record coders. They're high-priced commodity. In this particular IFB, and I tell you that what happens, an expert is someone who's made all the mistakes. Well, I will plead guilty to many mistakes in this procurement back in '89. There was no minimum reference or qualifications requirement in the IFB at all. Nothing said you have to have done this before. Nothing said anything about any minimum level to evidence competency of a vendor. But because of the pricing, because of the wishes of Health Services Cost Review not to take this untested vendor, and because I really wasn't too smart at the time, I simply said, okay, I'm going to find Mason to be non-responsible and one award to them. And Mason, when they were eliminated, did not take it quietly, to say the very least. I bid $20,000. I'm the lowest bidder. Give me the contract. I can do the work. No, no, no. You've never done this before. You don't understand. Your price is too low. You've never done it before. You obviously don't understand. So I'm finding you not responsible. No. I want this contract. I want it. Give it to me. And so the vendor did not file a protest. But it did do something else. Went to every politician that they could contact. And at the time, I actually was starting to wonder whether I was going to continue to be employed by the state of Maryland. Because when you have state senators and state delegates going to the secretary of your department and crying bloody murder and saying, here you have this fine Maryland vendor who won this fair and square, and here you have these bureaucrats taking it away from them. Unfair, improper. You, Mr. Secretary, have to do the right thing and you have to award this thing. And so for about a week, there was this great turmoil. And as I said, at times I was a little bit concerned because I'm the one that had said that you're not responsible, and I'm the one that had gotten the initial not polite response, and I'm the one that's being named in the letters that are coming from the state officials, the delegates and the senators. And before the secretary had to do anything, and I'm not sure if something might have happened behind the scenes, but finally Health Services Cost Review Commission said, all right, let's just award the contract to D.R. Mason. So they basically took the decision away from me, and they took the decision away from the secretary. They said, we'll go ahead and we'll let them do the contract and we'll just work with them. So, okay, fine. Good solution. I'm glad we were able to get out of that. And despite the bad situation, Health Services Cost Review tried to put the best light on the award. It had a work initiation conference with D.R. Mason to make sure there was good communication and clear understanding of the work to be done. And all discussions at that work initiation conference were summarized in minutes, and Health Services Cost Review Commission sent the minutes to D.R. Mason and said, here, this is to memorialize what we discussed and what was agreed to, and so if you have any issues with this, let us know. And there was no comment from D.R. Mason concerning the minutes. So everything is fine. All is right with the world for about a couple weeks. Now, going into a little more detail, almost all certified medical record coders work in hospitals translating written diagnoses and procedures into codes. So the way that you get medical records coders to audit medical records in hospitals is to go to the medical record coders that already work in hospitals, because that's where almost all of them are, and get them to work basically overtime or on weekends or something like that, and have them come in and go into other hospitals to do the same thing that they do in their own hospital. And because of the potential that a coder who works at Hopkins going into, let's say, University of Maryland may have some inclination to find errors in the coding that was done by their competing institution, one of the things that was, to a degree, hospitals are in the same geographic area compete with each other. We all see the commercials about, come to my hospital, I'm better than anyone else, we have better nurses and everything else. So at the Work Initiation Conference, it was stated by Health Services Cost Review Commission that there was a preference, and I will emphasize a preference, that coders that work currently in hospitals in the same geographic area as the hospitals that were to be audited would not be used, i.e. you don't take someone from Hopkins and send them to the University of Maryland. It might be okay to take someone from Adventist Hospital in either PG or Montgomery County and have them come up and do University of Maryland, but not someone from Hopkins. So that was a preference, that you get someone from outside the area of competition of the hospitals that were going to be audited. Preference. Well, and at the conference, supposedly what was stated is verbally, D.R. Mason said, not a problem. And this was recorded in the minutes, that this had been brought up and that D.R. Mason had said it was not a problem to comply with that preference. Okay? The audits were to be completed about 2 months after the conference occurred, the work initiation conference. So there was 2 months for D.R. Mason to go and get people to do these 2,000 audits of these codes. There was no concrete evidence that Mason was performing the contract. Number one, they missed the 2-month time frame. Bad sign, but again, I'm young, I don't know any of this stuff. I don't know that you're supposed to be on top of vendors and have good contract managing. So they missed the expected time frame, but they kept saying, yep, we're going to get it done. And they were allowed to keep making promises. And then one day I opened my mail, and here is from Mason a request for modification. Which the first thing I'm like, request for modification? Can a vendor do that? I'm like, gee, I've never experienced a vendor requesting a modification before. And my initial answer was, okay, they request. I say no. But what they wanted was an additional $8,880. They wanted the contract modified to give them $8,880 more money to do 2,000 audits, the same things they were supposedly contracted to do. Answer is no. You're just, well, I'm not going to give you more money to do what you already are supposed to do. The request for modification included the explanation that the preference to not use coders from geographically nearby hospitals caused Mason to use coders other than those it had intended to use, and the other coders that they had to then go and get from some other geographic area were more expensive than the coders that they expected to use within the geographic area. So they claimed we changed the rules, that we changed the specifications by adding that preference. And initially, because I remember I talked to my Assistant Attorney General and I said, what do we even do with this? Do we simply say, no, you're asking for a modification? So we'll say, nope, we don't intend to modify. And that was my first reaction, just say no. And then my attorney said, you know what? This, even though it doesn't say it, this is actually a claim. And so what she said is, we need to respond to this as if this is a claim and tell them what their appeal rights are and everything like that. So don't just say no, say, even though you have not identified this as a claim, we are treating it as a claim, and for these reasons, I deny the claim, etc. So that's viewing this as a contract claim, what would you do? So this is what I'm actually going to pose the question to you. Would you pay it? Would you request additional information? Would you try to negotiate it? Would you deny it? Anybody have any answer you want to? You have an answer?
Deny.
Deny. Anybody else? What would you do? From the minimum information you were given?
I would request more information.
You would request more information, such as?
Such as, you know, what quotas they have used.
What quotas?
Coders. You said they were...
Oh, coders. What coders they have used?
Yeah, and how much were they charging?
Okay.
You know, and then the other information that you can ask for is, you know, how much time it takes to review those medical records. you know.
We could ask them to provide information. Okay, you say you had to use different coders. Tell me who you intended to use initially.
Yeah, right.
Tell me who you got.
Right.
Tell me what you intended to pay them. Tell me what you had to pay
Yeah.
these people. Give me some other information that substantiates how you got to 8,880 more.
Well, I think that after the meeting, the conference, and they sent the minutes to Mason, since they didn't reply like, no, this changes the scope and the cost of what we would have bid. I mean, since they didn't reply to those minutes, I would say they should have raised the issue then,
So
not later.
which of those four choices would you do?
I would deny the claim.
So you were denied. And you would deny it based upon the fact, well, you didn't tell me when I wrote down in the minutes that you thought there was anything changing, and so I'm not going to accept that now you think there's something changing.
Right.
Plus,
Okay.
they missed the two-month deadline.
We didn't hold them to it. They missed the deadline, there's no question, but does that have an impact on whether they're entitled to more money?
No, that's it. They defaulted on the contract.
Well, yeah, we could have pulled the plug for that.
Right.
Anybody else? So we have 2 deny, we have 1 get more information. Anybody else that wants to venture? And you all say, no, turn the slides. Let's see, get on with the story. What was done? The claim was denied without seeking more information or trying to negotiate. The belief of all involved personnel at the agency, me, people at Health Services Cost Review Commission, our assistant AG, was that this claim was nothing more than an affirmation that Mason didn't understand what was required to perform the contract and had submitted a bid that was too low to begin with. So what we said was the case to begin with. This is just our validation that when they actually got to the reality of trying to hire coders, they were just using this as an excuse to cover the fact they didn't know what they were doing to begin with. I.e., as per the original not responsible determination, Mason was not capable of doing the work. So we said, from our standpoint, that's all this was. So we denied the claim. But Mason, obviously, the fact that we have a Board of Contract Appeals number to begin with, they appealed it to the Board of Contract Appeals. And there was a hearing. And after the hearing, the decision was that the request was a claim. So number 1, we had properly identified what it was, and that we had properly denied the claim.
Yay.
Key factors that allowed health services to prevail. Number 1, there was a work initiation conference. So that was a point that was specifically mentioned. And as you discussed, as you mentioned, what was discussed and agreed to at the conference was recorded, so they had done that. The written summary was sent to Mason. There was no comment from Mason that it disagreed with anything in the minutes. And that was specifically noted. The lack of dissent is consent.
Yep.
If I send it to you and you don't say anything, apparently you don't have any problem with it. If you had a problem with it, you'd have said something. And so that was a very significant issue to the Board of Contract Appeals. If they had a problem with it, they should have known at that time that it was, in their mind, changing the requirements. And if they didn't think it was changing the requirements, then that means that apparently it wasn't a valid claim. So there was no indication prior to the modification request that Mason felt anything recommended at the conference was a change to the specifications. They agreed to it verbally, recorded in the minutes, no disagreement with the minutes. So you agreed. Although the Board of Contract Appeals case was won, and by being won, what that meant was Mason had to perform the contract for no more money, and this is an important point. We won, but we lost. In fact, not only we lost, all parties lost. Procurement didn't do its job, meaning me, and I have learned, of delivering a good vendor, a good contract, and a good price. Mason never did the work, never produced anything of these substances. They did a little bit of work, but what they did was incomplete and unacceptable. They never got a cent. So whatever they did, whatever money they spent, they got no reimbursement for it. And what we heard via the grapevine, when you go to the Board of Contract Appeals, if you're not an individual, if you're a corporation, you have to hire an attorney. You have to be represented by attorney. What we heard through the grapevine was that D.R. Mason never paid their attorney for any of the work the attorney did in preparing for the claim, actually prosecuting it at the hearing, etc. So certainly the lawyer for D.R. Mason lost out. D.R. Mason never got paid.
But lawyers take advance.
Pardon me?
The lawyers usually take advance.
Well, in this case, I think they took the work on a promise of payment. Not a contingency, because
No, not contingency,
just,
but usually.
well, yeah, I'll pay you. And supposedly the lawyer kept billing and kept going after, and what we heard was the lawyer never got paid. Because this was something that they got paid upon performance of the 2000 audits. It was not a major contract. Do the 2000 audits, you get paid. They didn't do the 2000 audits, they didn't get paid. And here, Health Services did not have the information. So, Mason never got paid. They had actual out-of-pocket expenses of some degree they never got paid for, so they're out money. Their lawyer's out money. Health Services Cost Review doesn't have the information it needs to do its work. It took state time, my lawyer's time, time from Health Services Cost Review to deal with the claim. So even though we won, we didn't have anything. We didn't have to pay more money. That's the only thing we won.
So Joel, did you demand a formal apology from the politicians?
An apology from politicians?
Did you send
Oh,
them
wait.
copies of everything?
No. Yes.
So, looking back on this now, do you feel like it would have been better for the agency to hold true to its feeling instead of being pressured by higher ups just to give a contractor its job?
Looking back, at that stage of my career, with the pressure that was brought to bear, I was thankful that Health Services came and saved the day, so to speak. I mean, I'm not that I'd have been sold down the river. I don't think I'd have lost my job or anything like that. And even though I was, from my standpoint, it was totally valid and everything, the conclusion was valid, there wasn't enough to hang my hat on. I didn't feel enough comfort level. So we're going to get to what would you do in the future to avoid this, because we did things. Let me see. On the issue of Health Services Cost Review didn't have the information. The required information was to be used to help set hospital rate reimbursements. Now they didn't have the information, so they had less information to set hospital cost reimbursement rates. The next year, Health Services Cost Review did this again, and this time, instead of asking for 1 year's worth of audits, they now asked for 2 years' worth of audits, the year they wanted to and the year that never got done by D.R. Mason. How would you do things differently the next time based upon everything described in this example? Over here.
In your RFP, you have to put in there that they have to have so many years of experience.
Number one, you would put experience requirements. All right.
Qualification and experience requirements.
Pardon me?
Qualification, experience requirements.
Same thing. You'd specify something, evidence that they do this before. Same or different? Did you have your hand up? No? Yes.
In light of the fact that it's 2 years, I'd probably try to do something that would have a progress, you know. so-
Identify,
And that way you could identify that they're getting along or they aren't.
so you wouldn't have to wait till the end of the line and find out either they did it or didn't do it. Okay, so you'd know sooner. Yes.
Specify specifically that they have to have experience in medical audits.
Medical record coding and not just financial audits. Yes. Anybody else?
I also mentioned, I mean, again, the preference of using medical coders that are not in the same geographic area.
Would you say it as a preference, or would you go beyond preference?
A requirement.
Now you put it in the specifications that you cannot do that. So there's no question that that's something that you do not do. So you don't come in with your, allegedly, your price being based upon using the hospital next door, people from there. Anybody else? Okay. let's see. What was actually done? Second procurement was done via multi-step sealed bidding. So the first thing went from a straight sealed bid where all you get is a price to multi-step where you have a technical offer and you determine if the technical offer is qualified. A minimum medical records coding experience requirement was established. Give yourself applause and pats on the back. The recommendation to not use coders from competing hospitals, give yourself a pat in the back, was a clear prohibition. There never was a repeat of that situation. Over the years, because basically for many years, and maybe even to this day, I don't know, they did this same type of activity. And over the years, I know there were at least 2 other protests, but they were because a vendor was found to be not qualified at the initial stage. And one of them, again, went to the Board of Contract Appeals, and the state won that they had the legitimate reasons to find the vendor not qualified. And coincidentally, it was somebody who was an associate of D.R. Mason who filed this other appeal and lost at the Board of Contract Appeals. Just a coincidence. All right, any questions on that? So basically, believe me, from my standpoint, I learned. I thought, okay, you just tell a vendor they lost. And they say, okay, and go away quietly. Boy, was I wrong. Sometimes that might happen. But for the most part, a lot of times it won't. And when I said I wanted more ammunition, the ammunition was you change the procurement method, you put the requirements in there, you have the experience requirements so you can tell people up front, this is what we're looking for. And thus, if they don't have it, you can say you knew what the requirements were. And I felt a whole lot safer by doing these other activities because I had more that I could point back to than just my decision was you can't do it. So you learn. That's what you do. Negotiated claim example number 2, situation, Jessup Prison Complex medical contract. The contractor quoted a fixed per inmate monthly fee. So according to the number of inmates, it's a fixed fee to provide medical services in the prison based upon the maximum number of inmates that could be housed at the facility. And I have an example to explain what this means because some of this is hard for you to grasp just hearing this. This fee had to cover fixed and variable costs. The fixed costs were to be spread over the maximum number of inmates the prison would hold. There was no provision to adjust the fee if the number of inmates was less than capacity. So the requirement was that, let's say the capacity is 1,000 inmates. Take your price, divide it by 1,000, and that is a fixed price per inmate per month. Just whatever your cost is divided by 1,000 if 1,000 is the capacity. The Jessup prison population decreased. One of the times when that happens. In around 1999, there was a prison disturbance. So obviously we're talking about something that happened in the somewhat past. About 700 prisoners were transferred out of the Jessup area prisons to prisons elsewhere in the state where the medical service contract was not with this vendor. It was another vendor. So because of the disturbance, we have to decrease the population. 700 people are taken out of Jessup and sent to Somerset County, to Hagerstown. I guess that's all they were. They didn't have Cumberland then, I don't think. The vendor who was providing the medical services in Jessup requested a modification of the contract to get a higher per inmate monthly fee because the price I gave you was based upon a population of 1,000, and I was covering my costs by this per inmate fixed fee for 1,000. But now that I've given you this fixed fee per inmate, when there's only 700 there, I've just had my income decrease by 30%. I need more money because my fixed prices haven't gone down perhaps at all, or if they did go down, it wasn't by 30%. I need more money. And the initial answer from Public Safety, Department of Public Safety and Correctional Services, was no. Fixed price per inmate per month based upon capacity. The capacity was 1,000. That's what you bid, that's what we'll pay you. And even though there's only 700 in there now, we'll pay you that fixed price times 700 now. the vendor filed a claim. Example, so this is to try to put some flesh to it. If the fixed cost to provide medical services at Jessup was $1 million per month and there were 1,000 inmates, the per inmate monthly cost would be $1,000. That's what the vendor would have charged as their fixed fee. If the per inmate monthly cost was fixed at $1,000 and there were only 700 inmates, monthly income would come to $700,000 a month, so the vendor has $300,000 per month less income. So that's how you put this to numbers. And to break even at 700 inmates, and if we assume $1 million is their fixed monthly expense, if they were dividing it by 700, the price to break even at $1 million would be $1,430 per month. And so that's what the vendor said. I base my price upon the former capacity. Now there's 700 fewer. I can't make money at that fixed price with the number of inmates that are now at the facility. What was done? Since public safety had deliberately removed the 700 inmates, this was not an unforeseen circumstance. The determination was that an unforeseen circumstance that the contractor would have to absorb. So what public safety did to the vendor was basically agree that we changed the rules on you. It wasn't just natural attrition or anything like that. This was specific, deliberate action to take 700 inmates out. And so I said, okay, so we will, if you will drop the claim, we're talking about this as a negotiated settlement. So if you will drop the claim, we agree to modify the contract to compensate for the number of prisoners removed, but we would only compensate you for the 700 transferred. There were actually 1,000 fewer, of which only 700 was attributable to that specific action. 300 were just natural attrition. And so they said, we'll pay you for the 700, but not the 300 or anything else that the census is down by. So if you agree to that, we will submit a modification. So a formal settlement was agreed, was signed by both parties. The settlement was contingent upon all required state approvals being obtained for the modification. DBM and the board approved the modification. And I can remember when this first came to me, I had a whole lot of issues with it. And I went back and forth with the procurement officer at Public Safety and said, but they're on the hook, and we went, as I said, we went back and forth, and finally the procurement officer at Public Safety convinced me that this was a good action on the part of the state, and it was much better than if this went to the Board of Contract Appeals, and who knows what they would decide. And so I said, okay, I'll send it on to the board, and the board approved it, and so then the modification was approved, and the settlement was withdrawn, and everything was fine. So that is another example of a negotiated claim. A formal negotiation led to a modification, and the claim was withdrawn, and supposedly they lived happily ever after. Not really, because there were claims after claims after claims on this contract, but that was one example. All right, answer for the future. What would you do in the future? The issue of, and probably there should be some kind of transition here. Since you had this situation and we came to a negotiated settlement, does that mean that there was something inherently wrong with the specifications that needed to be revised the next time this was done?
Yes.
Yes, you think so? What do you think should be done?
Obviously, the number of inmates are going to go like this and might go like you said. There should be something in there that would allow the vendor to make an adjustment.
So you think it would be better off for the state in the standpoint of reducing risk, therefore hopefully reducing prices in the future?
Absolutely.
Because once a vendor is burned in something like this, at the very least that vendor is going to come back with higher prices.
There is.
And since vendors know each other and they know what each other are experiencing, especially when you have claims and things like that, and stuff goes to the Board of Public Works, they know the situation, so even if the one vendor doesn't bid again, other people are going to know that this is a potential problem, so theoretically everyone the next time would have bid more. So let's see. So the options are, would you do something in the future? First answer is, well, maybe not. We've gotten away with it to this point, and even though we had a modification, we still dodged the bullet on at least 300 inmates reduction we didn't have to pay for. So we can just leave things as they are and see if vendors will continue to respond in a reasonable price. That's one option. But the other option is exactly as you said. Assuming vendors won't want to assume the risk in the future, the financial prices could be the amount of fixed costs converted into variable costs, i.e., and what that means is you could take the monthly inmate fee, could be allowed to vary according to the number of inmates into the fixed fee. Have them bid the fixed fee, and the fixed fee is the bid amount, and then each month you have the census, and you simply divide. In fact, I don't even know why you have to do it by census if you just have a fixed fee, but that's one way that could have been done it. And you could have added a variable fee, and that is the per inmate fee to change each month, charge each month, and that's eventually what was done. So they changed it in the future to take less risk on the vendor, more risk on the state, to allow the vendor to get, I guess, adequate compensation for changing census levels.
Because you know the population is going to...
Population is dynamic, and usually it goes up, but as you open more prisons. Since they opened a prison in Cumberland, and I think they expanded some of the other ones, and then they just opened another prison in Cumberland. So when you do that, you can transfer people out of certain ones. So there are changes. An exercise that we won't do. Okay. It's lunchtime. What a coincidence.